Hello. I would like to welcome everyone to today's Meritas Capability webinar, Doing Business in California, Proposition 65, the California Green Chemical Initiative, and the Rigid Plastic Packaging Regulations. My name is Crystal Dahl, and I am the Online Communications Specialist here at Meritas. Today's webinar will be presented by Meritas member Lee Smith from our Sacramento affiliate Weintraub Tobin. Lee's practice includes environmental compliance, including Proposition 65 and food safety. He has handled cases before the Central Valley Regional Water Quality Control Board, the San Joaquin Unified Air Pollution Control District, and local environmental agencies. He has also been involved in state court litigation concerning the California Environmental Quality Act and Prop 65 litigation, as well as federal litigation involving the Clean Air Act and the Comprehensive Environmental Response Compensation and Liability Act. Mr. Smith has defended a wide variety of defendants in Proposition 65 compliance and litigation, including large hardware and plumbing suppliers, as well as food and drink producers and supplier and clothing manufacturers. Before we get started, I would like to go over a few housekeeping items. As many of you have likely noticed already, all telephone lines have been muted. If you have a question for Lee, you are welcome to ask via the chat feature found on the left-hand side of your screen. Lee will plan to answer your questions at the end of the presentation. If you experience any technical difficulties, please press *0 at any time to connect with the support technician. With that, Lee, are you ready to get started?
I'm ready.
Great. Go ahead.
Good afternoon or good morning, as the case may be. I'm going to cover three main topics, and there's a lot of material here. So to the extent that I don't cover an issue that you'd like to talk about, feel free to contact me afterwards. I'll be happy to go over some of this material with you. I'm going to talk about Prop 65. I'm going to talk about the green chemical regulations and a lesser-known statute and regulations concerning rigid plastic containers that we have here in California. Prop 65 originated as an initiative back in 1986, and the original purpose was to provide warnings to consumers and employees of chemicals that they might be exposed to. I've included the standard Prop 65 warning label that we see on most products that require it. The proposition does, most importantly for our purposes, contains a bounty hunter provision that's made it a very fertile area for environmentalists and less altruistic plaintiffs' counsel to bring a lot of companies into court and into settlement conversations over different types of products that probably didn't ever expect to be there. Another related issue is under California Civil Procedure 1021.5. In California, we have a private attorney general's provision that allows the plaintiffs in these cases to recover their attorney's fees, which in many cases is the larger portion of a settlement that a plaintiff or defendant may enter into. Recent cases, just to give you a feeling for what's going on, they kind of come in waves. Different types of cases. Right now, there's a large number of furniture padding cases that are related to the fire retardant that's used in the foam. There's a number of recent seafood cases alleging that the seafood contains lead. Previous cases that I'll talk about a little bit are baby food, fruit juices cases where they allege there was lead in the product. There's a series of vinyl products, purses, shoes, and that are alleged to have phthalates. There were some cases involving diesel exhaust in parking lots, secondhand smoke in hotels, and for a while there was a large spate of cases that involved exposure to alcohol and smoke and cooking fumes in restaurants. Other chemicals that are of interest: cigarette smoke, the Prop 65 chemical, diesel fumes. Sawdust is an interesting chemical. There was a number of tool manufacturers required to label their products because of the sawdust that's produced when they're used on wood. Sulphur dioxide, ethyl alcohol are all Prop 65 chemicals. The operative language in the California Health and Safety Code: no person in the course of doing business shall knowingly intentionally expose any individual to a chemical known to the state of California to cause cancer or reproductive toxicity without first giving a clear and reasonable warning. Just as a side note, there's a parallel part of the statute that doesn't allow the discharge of these same chemicals into waters of the state. Exposure means to ingest, inhale, contact via body surfaces, or otherwise come into contact with listed chemical. You should know that there are really three types of exposures. There's exposure is to a consumer, usually with a product, to an employee, or in general environmental exposure. The language, it contains the word knowingly, which you would think has meaning with respect to whether or not you knew you had the chemical in your product, but there's very little case law on that, and most, as we'll discuss, most cases never get to the point where those types of issues are ever litigated. So it has very little meaning, although it's raised as a defense in most cases. Again, the broad range of chemicals are over under 850 Prop 65 chemicals, a number of common chemicals, which I noted. And again, there are a number of those chemicals that are commonly found in food and beverages. There's the listing provision. I'll try to go through this section pretty quickly. But in California, for a lot of people, the action is in the listing. A lot of chemicals, if you can keep them from being listed or listed in certain different ways, you may be able to protect your clients from having to deal with the statute. The list comes from a couple of different places. It comes from the Labor Code. A chemical is listed if it's put on the list by one of two independent agencies that are at the state. Chemicals are only supposed to be listed if it can be clearly shown through scientifically valid testing according to accepted principles that they cause cancer, reproductive toxicity. Other ways to be listed are if another authoritative agency has already listed them. Another way is if they're labeled by an agency for having cancer, another agency for having cancer or birth defects, such as with prescription drugs. A fourth way to list was with the Labor Code. If there was an issue related to OSHA and you were on the hazardous list on that Labor Code, that the chemical could automatically be listed in Prop 65. And as we'll talk about, there was later case law that made that more difficult. There were two sets of code sections in the Labor Code, one for human and animal carcinogens. Another Labor Code brings in chemicals that are part of the Federal Hazard Communication Standard. As I mentioned, there's a case, Styrene Information Research Center versus OEHA, in which case the court held that they actually had to have human or animal studies showing that there were carcinogen or reproductive issues instead of just moving things over from the Labor Code lists. So for that reason, a number of chemicals that were in line to be listed have been taken out of the line, and some of the chemicals that were listed have actually been delisted. Limitations on the statute. It only applies to companies with over 10 employees. There may be federal preemption. There's a meat packers case I'll talk a little bit about further down the line. It doesn't relate to occupational hazards covered by the HAZCOM standards. There's an exemption for prescriptive drugs, and the actual regulation of the chemical doesn't go into place until 12 months after it's initially listed. There's also one of the major provisions is that the warning requirement isn't necessary if you can show that with respect to cancer risks that the exposure poses no significant risk level, the NSRL, which assumes a lifetime exposure, and it's a 1 in 100,000 cancer risk. With respect to reproductive hazards, they look at what they call the no observable effect level, which assumes exposure at 1,000 times the level in question and whether there's an effect. They use that number to identify in many cases, what would be the maximal allowable dose level, usually on a daily basis, to determine whether or not it's a chemical that needs to be labeled. The labels, the warnings have to be clear and reasonable, must be reasonably calculated considering the different methods available under circumstances to make the warning message available to the individual and prior to exposure. DTSC has issued safe harbor warnings in the statute, which I've included some further down. Although in the safe harbor levels, if you use those warning labels with that particular language, it's presumed that you're in compliance. Although the statute does say you can use other warning language or labels as long as you provide the sufficient warning. Again, there are three different types of exposures, and each of them will require essentially different types of warnings or labels. There's a consumer exposure, environmental and employment-related exposure. With respect to consumer exposure, we're talking about product labeling or identification of the product at the retail outlet, perhaps on signs, shelf labels, or on menus, or a system of signs, public announcements, identifying the system, and perhaps toll-free information. And there is some case law on those issues. The contents of the warning, again, there's a safe harbor warning, and I've included the safe harbor warning here for chemicals. For cancer is the first one, and the second one is one that's used for reproductive risks. There's also a specific warning for certain food products. There's one for food, and there's one here that's used for alcoholic beverages. Again, here's the alcoholic beverages warning language. With respect to occupational exposures, the label must be displayed where it can be seen and read to the individuals. It must be conspicuous, and it must comply, and a warning that does already comply with some of the other requirements may be sufficient. Environmental exposure, that's the type for the sign you would see in a restaurant or maybe at a gas station. They must be in an area where the exposure occurs. They must be delivered to occupants if that's an issue, or public media announcements are also allowed. Where do the warnings go? With respect to consumers, it must be on the label. Again, this is really just the language that I spoke about earlier. Shelf labeling, signs, menus, combinations thereof, and they need to be done with such conspicuousness as compared with other word statements. Designs or devices in the label already so that they stand out and people actually have an opportunity to see the warning. These are a couple of cases where kind of interesting issues. There was a case that related to dental products, and it was found that the warning given to the dentist and his assistant was sufficient, and that there was essentially an implied duty from the dentist to give that warning to their patients. There's cases where, with respect to grocery stores, where they tried to post 800 numbers, and that was found to be insufficient. And there was a case with regard to vaccines where they determined that the informed consent required from the doctor-patient relationship was sufficient to comply with Prop 65. So do you need a warning? How do you know whether you need a warning? You need to know what's in your product. You need to know what the dosage is under different situations. You need to know whether you exceed the NOELs or the MADLs. You need to know if there is a MADL or NSRL. Some of them have not been set yet, and in certain circumstances you may have to hire an expert and determine your own levels. Enforcement of the statute is essentially by the Attorney General. An example of cases where the Attorney General has been involved is in the acrylamide cases and lead and fruit juice cases. It's up to the Attorney General. Most of the cases aren't handled by the Attorney General, but as I'll go through the procedure, there's a procedure for the Attorney General to be given notice as to whether of a case that's pending, and they decide whether or not they're going to get involved. And they essentially only get involved in cases that they feel the state should be involved in. Under the enforcement sections, a person that violates or threatens to violate may be enjoined. The penalty provisions are, at least by statute, are $2,500 per day for each violation, which essentially would mean if you were selling products, could be each product that you sold. In the statute of limitations, essentially 2 years, so you would go back 2 years for the products you sold over the last 2 years that were allegedly not properly labeled. In assessing the penalties, the court's supposed to take into account the nature and extent of the violation, the number and severity of the violation, economic impacts, whether you took good faith measures to comply with the chapter, the willfulness of the violator's conduct, the deterrent effect of violation, the penalty might have, and any other factors that justice might require. Some of the procedural aspects, there is, like I indicated, a 60-day notice that goes out to all of the prosecutors in the state, gives them an opportunity to review the case and decide whether they want to jump in. More recently, there's a requirement now that each 60-day notice have a certificate of merit where an expert or an attorney indicates that he has talked to an expert and the case has merit. Again, notice to the prosecutors. Settlements must be approved by the court, and they also go to the AG to be approved prior to the time they go to the court. There are informal settlements that are done outside of the court. The question of whether those are sufficient to show res judicata. So most cases now are being taken to court and having the court's blessing on a consent judgment. Essentially, under Prop 65, the plaintiffs, after they've served the 60-day notice, they obtain a right to proceed in the public interest. When they obtain penalties, they get 75% of the penalties. 75% of their penalty goes to the state, 25% goes to them. But again, most of the recovery from on the plaintiff side would be with respect to attorney's fees. Again, there's a 60-day notice. The purpose is to give the government a chance to get involved. There's also a secondary purpose that's sometimes overlooked, which is an opportunity to give the defendant a chance to cure the violation. If there's insufficient information in that 60-day notice, they may be prevented from proceeding. The 60-day notice essentially will identify what chemicals are at issue, what products are at issue, and then have the certificate of merit attached to it as well. Again, this certificate of merit is an expert declaration that the case is meritorious. If the court finds after trial that there was no actual or threatened exposure, there's a possibility of getting sanctions with respect to what was in that certificate. However, most cases, since they don't go to trial, you never get to the point where you're able to actually attack their certificate, and you're also prohibited from doing discovery with respect to the certificate until after trial. The defense is to Prop 65. There's a federal preemption defense for cases like FIFRA, or as I said, there's a meat packers case. Safe harbor levels, which we talked about, and there is a very important defense for mostly for food processors, that is whether or not the chemical that's in the product is naturally occurring, and I'll talk about that in a minute. As I indicated, there are some statutes that have been found to preempt Prop 65. There was a meat labeling case where they found that the procedure for inspecting meat and labeling meat was sufficient to preempt Prop 65. More often than not, though, the courts are finding that Prop 65 is not preempted. There was a poultry case where they found the types of inspections done for poultry weren't sufficient for preemption. And in the Beech-Nut case, which I will talk about a little bit later, that recently the trial court found that there was no preemption on certain food products. Again, there's no warning requirement if you're less than the NSRL or the MADL. The burden, however, is again on the defendant to show those exemptions. The safe harbor levels for a number of for some more common chemicals are here. You can see some of them are fairly low. The 0.5 micrograms per day for lead is pretty low. The MEI, which is a coloring agent that was used in products like Coca-Cola, Pepsi, is also fairly low given the type of material. How do you determine the thresholds? Some of the thresholds are set and are in the regulations. Otherwise, you have to hire an expert who will quantify the chemical concentration in the chemical and then determine what the actual exposure is. They multiply that level by the anticipated rate of exposure to a particular individual. This is really more applicable to food products. And then the rate of exposure that they use must be based on the pattern and duration of the exposure relevant to the effect, what type of effect that the chemical has on the body. Again, safe harbors are either set by the regulation, they can be set by experts. More frequently, because these cases wind up settling, A lot of the safe harbor numbers are actually set by the parties as they settle these cases. So if you're handling a case and you're looking for the safe harbor number, you may have to look to the consent judgments that have been entered on that particular type product to find out what may be considered to be a safe harbor level. The natural occurring exemption is difficult to prove, as we found out in recent litigation. The defense requires that the chemical at issue be found to be naturally occurring. It can't be man-generated, and you must be able to also show that you've done as much as you possibly could to remove that chemical from your product, even if you can show that it was naturally occurring. The original case on naturally occurring was a tuna case, and in that case, even though the burden was on the defendants, the court actually found that the plaintiff didn't provide sufficient evidence to show that it was the mercury, that the mercury that was in the tuna was not naturally occurring. There's no duty to label if you can find it's naturally occurring, but only again to the extent you could prove that there's no man-made component, and this could require extensive research. Some folks have gone back to the actual fields where their product is grown to try to prove that the lead levels that were discovered were not due to anything but natural. So it becomes very expensive and difficult to prove. And like most of these Prop 65 cases, it becomes a business decision that it's less expensive to settle a case than it is to go through all the hoops in order to try to prove and try your case. The most recent case, and I think there's some folks that were involved in the case on the phone, was this Environmental Law Foundation versus Beech-Nut case, which was a case, Superior Court case that came out in over the last summer, and it involved lead allegedly to be in fruit juices, and the court in that case found that there was no federal preemption because the FDA labels that were on these products were not arguably are not necessarily to be approved by the FDA. The court found that there was insufficient proof that the lead was actually naturally occurring versus what was man-made, and also there was an argument that it was not sufficient things were done to make sure that there was that the parties didn't go to the extent they should have to try to make sure there was no lead in their product. The good part of the case was that they did find that the exposure assessment, finding the safe harbor levels, was done correctly, and in this case, the court allowed a procedure that a lot of the parties have been using in the past, but it wasn't clear, especially with respect to reproductive harms, whether you could use this. And basically, they averaged the dosages and averaged the levels of lead over the period that they were being consumed, rather than looking at the peaks. Because, for instance, a peak may go over the MADL level on one day, but maybe lower on another day, and the court allowed them to average it, and they were able to find that these products were all below the safe harbor levels, and they were able to defend the case. Settlement issues, again, most of these cases wind up settling. It's too expensive to go through the litigation process. It's usually a business decision where your clients have to weigh the litigation costs versus settlement costs. There's the question of whether you're going to, provisions that you find in the agreement many times will be requiring that you either label or reformulate. We're finding more and more that the plaintiffs, in order to try to claim their attorney's fees under 1021.5, are required to show that they did something above and beyond what was required by the statute. And so you find that in a lot of these settlement agreements now, the parties are being required to go further than they would have under the statute. So you may not be able to just label your product. You may have to reformulate it. As I mentioned in the past, a lot of the settlements were done outside of the court process in order to save fees. However, because of the number of plaintiffs' attorneys and the number of products and the doubling up on the same products, it's important to take your case to court and have it resolved there, because then you can argue that it's res judicata as to the Prop 65 violations for that particular product. There's been some recent issues with the scope of the releases and the documents on the settlement. in California, you are allowed in most private cases to release future claims, future and unknown claims. The Attorney General is taking the position that if the plaintiff is acting on behalf of the public, that they can't release those claims on behalf of the public. So many times in these settlement agreements, you will have both a release from the plaintiff as an individual, and then a release that doesn't release future claims from on behalf of the public. Again, any judicial settlement, and actually the informal settlements must be passed by the Attorney General part of the time they go to court. Most cases, the Attorney General does not get involved. Recently, the Attorney General has been watching the ratio of penalties versus attorney's fees, recognizing that the plaintiff's firms are making more money off the attorney's fees than they do penalties, and many times you can get low penalties but high attorney's fees, and the Attorney General has commented that on several occasions. Right now with the furniture cases, there's over 300 defendants, and given the attorney's fees that they're claiming, the Attorney General, I believe, is looking at that issue as well. Example of, again, just listed chemicals relevant to food products. There's acrylamide that was in potatoes and coffee and different cooked chemicals. Phthalates that are in handbags or vinyl products. Cadmium that was found in jewelry, lead, handbags, shoes, and other plastic materials, and arsenic in water filter systems and supplements. Recently listed chemicals. Coconut oil was recently listed. There's a spate of new cases relating to shampoo and soap and other cosmetics that use coconut oil. Methanol was an issue, but the industry was able to minimize the types of methanol that are subject to Prop 65. The tris, which is the one on the bottom, is the chemical that's involved in the in the furniture cases. 4-MEI, again, I mentioned that earlier. It's a coloring agent that was involved in Coke and tea and some other products. A number of those parties have been sued and being required to reformulate their products to remove or use a different chemical. Sulphur dioxide, which is used to preserve certain types of fruits, was listed, but again, the industry was able to minimize the effect that this listing has on their products. I just wanted to mention a couple of settlements. The acrylamide case was settled, and the Attorney General was involved. That had to do with the acrylamide, which is actually generated in the cooking process. As part of the settlement, there was a specific label that was used, and I've provided that to you right here on this slide. Just as another interesting note, there's some recent case law with respect to chemicals that are the Prop 65 chemicals that are actually created by a chemical reaction in the body after somebody has been exposed or has ingested something, and the court held that was not the warning label, that the products were not subject to warning in those instances. There's also recent legislation. At the beginning of this year, there was an effort to amend Prop 65 to make it more business friendly, make it more difficult for plaintiffs' attorneys to bring cases. However, it turned into a struggle to keep them from actually making the statute more stringent. There was legislation passed that does amend the statute in a good way, but what it wound up really doing was only affecting environmental exposures. And I've set out some provisions of the bill here, but essentially it allows, say, a restaurant or someplace that was required to put up a warning sign. If there's a violation, they have a certain number of days to cure the violation, and then there's a minimum amount of penalties. I've included the specific chemicals that are subject to that statute. Exposure to alcoholic beverages, food and beverages prepared or sold on a violator's premises, or exposure to tobacco smoke. So that should eliminate a number of the cases that were recently brought, similar to ADA cases, where they would go into a restaurant, find that there was no warning sign and bring Prop 65 cases. Now there's an opportunity to settle those cases at a very low amount and cure the problem. What type of products are hot right now? As I said, the cases kind of go in waves. As I indicated, they're the DEHP cases, plastic tools, vinyl clothes, purses, DHP, and eyewear. There's a whole series of cases now relating to glasses. The tris and furniture, which I mentioned already, lead in various types of food. There's been a whole new series of seafood-related lead cases that have recently been noticed. The restaurant cases, like I mentioned just previously, flame-cooked ground beef gives off certain emissions which were subject to Prop 65. There's recent cases on arsenic in rice, lead in dietary supplements, and I also mentioned previously the coconut oil in cosmetic soaps and shampoos. Our conclusion with respect to Prop 65, you need to know what's in your client's products. You need to look to your upstream suppliers and get indemnities to make sure that they indemnify and agree to defend you if their products aren't in compliance with the law. You should get your client should get insurance if you can, although Prop 65 insurance is pretty difficult to get. And then again, just keep in mind that a lot of these cases, although there are significant legal issues and significant defenses that may apply, you wind up settling these cases based on the business decision weighing out your costs versus what the cost of litigation might be. I'm going to talk about now the more recent legislation and regulations, which is the Green Chemistry Initiative. In 2008, and Governor Schwarzenegger started a Green Chemistry Initiative, and it was the purpose was to accelerate the quest for safer products. The regulations and authorizing statutes, health and safety code, that were passed and the regulations promulgated were intended to implement the final report that Schwarzenegger's people provided with respect to green chemistry. California Safety Code Section 225253 requires regulations to establish a process for evaluating chemicals of concern in consumer products, their potential alternatives, and determine how best to limit that exposure to reduce the level of hazard posed by that chemical. So the difference between this and Prop 65 is all that Prop 65 is supposedly is a labeling, a warning. You have to provide warning to people if you're going to expose them to chemicals. The Green Chemistry Initiative, on the other hand, is an attempt to actually change the constituents of particular identified products to make them more safe. In summary, the questions that they ask under the statute is the particular ingredient at issue necessary? Is there a safer alternative? And is that alternative ingredient feasible? And although we've set these questions out and they seem simple, the regulations are extremely convoluted in how you're going to go about that. I'll talk about them just in general in terms if you're interested in more detail. I'll be happy to provide it. A consumer product means a product or part of a product that's used, bought, or leased, or used for a person for any purposes. Consumer product in the instance of the Green Chemistry Initiative does not include drugs, dental, restorative materials. Food has been left out, although it's not clear whether the packaging for food is left out. Pesticides are also exempt. The statute requires an evaluation of the availability and potential hazards posed by those alternatives, an evaluation of critical exposure pathways, and a life cycle assessment tools are included in the regulation. From a list of candidate chemicals, the DTSC is supposed to identify chemicals of concern, and then they are going to identify priority products for which analysis of the alternative analysis I discussed would be required. The list of chemicals was actually released in September, and it appears that at least 50% of those chemicals are those that are already on the Prop 65 list. And then if you look at the regulations, there's a whole series of other places where they've taken other chemicals from to put them on this list. Now that the list has been established, the DTSC now has to identify 5 priority products. In evaluating those products, the DTSC is supposed to consider the potential for exposure to the chemical, the potential for that chemical to create adverse health effects and the potential adverse health effects from the disposal of those particular products. 180 days after the regulations came out, which would be April 2014, the priority products list is supposed to be out for public review and comment. And obviously, if your clients have a product on that list, they need to get busy. The list is not supposed to be more than 5 products. And from our understanding of interviews with DTSC folks, at least 3 of the products will include toluene that's in nail polish, carpet adhesive that has formaldehyde in it, and mercury in fluorescent light bulbs. Once they identify those products, if the manufacturer decides to continue to sell that product in California, there's a series of hoops that they'll need to go through. There's also provisions in the statute as an aside for listing and delisting candidate chemicals and for petitioning to remove priority products as well. There's also, unfortunately, an avenue for adding for public to add chemicals to lists and also to identify priority products that they feel should be identified. 60 days after the product's included on the priority products list, the entity responsible for the distribution of that product, identified as responsible entity, notifies the DTSC and submits a preliminary alternatives analysis report, and that report to be submitted no later than 180 days after that product's been listed. If that report's accepted, they then have 12 months to submit a final alternatives analysis report, which is reviewed by DTSC. If you look at the regulations, it's a complicated report with respect to how the chemical is used, what alternatives the chemical can be used, and it goes as far as looking at disposal methods for the chemicals as well. Again, here are the factors to be considered or alternatives that avoid or reduce adverse impacts, the redesign, the degree that the report can address those impacts, the ability of the ultimate user to understand information or directions provided with that product, and then what the cost of the alternatives would be. The DTSC then determines whether additional actions are required. There's a number of additional actions that can require, including additional information, restrictions on the use, or requiring additional safety provisions for particular products. As I indicated earlier, an analysis can be avoided if the chemical of concern is removed from the product, if the product is no longer sold in California, or a substitute chemical is already being used by a manufacturer in that product. And for each of those, you would have to provide a report to the DTSC to explain that. Who has to comply? Generally, consumer product manufacturers have the primary responsibility. The manufacturer is not in compliance. The duty then falls on the importer into California upon notice of noncompliance by the DTSC. If both the manufacturer and importer fail to comply, then the assembler or retailer would be responsible once the DTSC posts a notice on its website. And to avoid penalties, that business would discontinue selling that particular product. What should manufacturers and distributors be doing now? It's unlikely that most companies will be affected other than those who are going to have priority products, but they should be checking the list of chemicals with their supply chain vendors to ensure that they're aware of these requirements. The regulations have short timelines. If you are a company that does have a priority product, you have a very short time period, although there is a provision for getting extensions for providing the reports that are required. Additionally, supplier contracts, again, should be revised to include warranties or representations to perhaps look towards vendors to cover the cost of some of these issues. I'm now going to talk about the last and least known statute. It's the California Rigid Plastic Packaging Container Program. This act was passed, unbeknownst to most folks, in 1991 as part of an effort to reduce the amount of plastic waste that goes to landfills in California. In summary, it requires manufacturers that sell products with certain types of plastic containers to either use less packaging, more recycled materials, or assure that their package is reused or recycled. What packages are covered is the plastic container, a relatively rigid shape, or form. It's a minimum capacity of 8 ounces or a maximum volume of 5 gallons. There's provisions in the regulation that tell you how you can measure that. The packages also must be capable of at least being closed one time, even if that's only during the manufacturing process. And obviously, it's one that contains a product that's sold in California. Selling is direct sales as well as products offered for sale in California, including retail sales, remote sales through distributors, wholesalers, and most importantly, the Internet. Examples of products that might be in rigid plastic containers: adhesives, cleaning products, hardware, paints, arts and crafts, computers, lubricants, sealants, automotive parts, electronics, office supply, and toys. Types of containers that we might be looking at are buckets, tubs, pails, tubes, rounds, jugs, bottles, clamshells, plastic folding cartons. Exemptions from this statute: food, drugs, cosmetics, baby formula, medical devices, products subject to FIFRA, products subject to the DOT regulations for hazardous material shipping, and then rigid plastic containers that you can show are destined for shipment to other destinations outside the state and which remain with those products during that shipment. The process leading to certification with the Cal Recycle is in a phased. The manufacturers selling potential products are given advance notice by Cal Recycle that that product has been identified and may be required to certify compliance. Once the manufacturer, is notified, then they must register, even if they believe that they aren't subject to the statute. They may have to register in any event. And later, if they are the department will then identify a number of the registrants to go through the certification process, and at that point in time, you can raise your defense as to whether or not you're actually subject to the statute. The process of certification is set out in the statute would be very time consuming, especially if you have more than a couple of products that are in these types of containers. It requires detailed information concerning the manufacturers, the containers, specific information concerning compliance options, and the ability to, and again, you do have an ability to request an exemption at the time that they require certification if they do. The compliance options that you're required to show that you're certified with, you must show one of the above, that you're using at least 25% post-consumer resin in your plastic, that perhaps you've reduced the amount of plastic you're using by 10%, or that you show that the product package is used or refilled at least 5 times. And although there's a lot of products that may fall into that category, the question of how you would prove that it's refilled that many times is kind of an interesting question. Or you can have a recycling rate of 45% if it's brand specific. Again, proving that may be difficult. So what do you need to do? Your clients need to be in compliance with the statute. They need to be prepared to argue that there are exemptions if they're required to do so. They need to document compliance with the statute, and they need to retain their records for at least 3 years. The law was revised in 2003 to clarify some confusion with the regulations. However, if you read the revisions, it actually causes more confusion, I think, than it actually cleared up. Originally, the law only regulated products that were capable of multiple closures. Now the regulation says only capable of 1 closure. It's not really clear what that means. Packages that were originally that were only partially made of plastic, if you had a plastic but had metal hinges, it wasn't covered. It's now covered. Products that are capable of being folded so they're not totally rigid are also now included. And then there's a definition of blister packs that are covered and some that are exempt. Violations of the statute. There are penalties for violations for not submitting your certification by a certain date, by not completing the certification by a due date, or not providing accurate information, or for submitting false information to Cal Recycle. Cal Recycle annually reviews a percentage of registered products to verify that there's compliance, and failure to comply can result in penalties up to $50,000 for any violations, and that's not to exceed $100,000 on an annual basis. So final suggestions for all of these statutes. Again, you need to know what's in the product. You should attempt to place the contractual onus on your vendors or suppliers. Insurance, if you can get it. If you're in a Prop 65 case, you should try to negotiate a settlement before the 60-day notice runs out. Many times you'll need an attorney who's experienced in this area, and many times you need an expert who can work with you on exposure issues. And then again, you need to explain to your clients that a lot of these cases are resolved based on business decisions rather than justice or the law, but it's easier to or cheaper to settle it than it is to go through the litigation involved in these types of processes. I've got my contact information here. I'm going to see if folks have any questions. I know I went through that material quickly. If you have any questions, I'd be happy to respond.
Lee, it looks like Zachary has a question.
Okay, I'm looking at it.
Do you want me to read it?
Yeah, it's not on my list.
Okay. He said, is a warning on a packaging slip for a consumer product sufficient?
On a slip?
Yep.
Like a sales slip? I would. That's a good question. I think the argument would be whether or not the client whether or not the consumer was able to see that warning at the time they purchased the product, or essentially before they purchased the product. So that would be the issue. I know the Attorney General's raised that issue, so it's kind of a matter of timing. I think you could make a good argument that it's sufficient, but it would have to, again, meet the requirements. It's more of a practical question. Is it a sufficient warning that they saw it, had an opportunity to see it before they bought it, and also before they were exposed? There's some discussion about, for instance, one product that's covered. There's certain types of electrical wires that are covered with rubber that are covered, and there was an argument that if you waited until you got to the point of sale to see the warning, then you may have picked it up in the store and already been exposed. So again, it's a matter of timing. It probably depends on the product, but generally you could probably make a pretty good argument, but you need to take all of those different factors into account.
Does anybody else have any questions for Lee? It looks like that might be it, Lee.
Okay, good. Okay, as I indicated, if anybody has any additional questions, feel free. I know I went through that material fairly quickly, but I'd be happy to discuss it with anybody.
Oh, Zachary just brought up another question.
Okay.
It says typical amount of Prop 65 settlement.
Oh, that's a tough question. There's if you go to the AG site, the California Attorney General's site for Prop 65, you can see it's usually it lags by like 6 months to a year, but there's a list of the settlements and the amounts. It depends. It depends on the plaintiff's attorney that you're working with. Arguably, it also should depend on a lot of times the number of products that you've sold into the state, because the penalties are supposed to be based on the number of alleged violations you had in the next 2 years. They're supposed to take into account the actions you've taken once you were on notice that you might have a violation. But I would say, again, it's very factually specific, but you see settlements that generally can run from $15,000 to $20,000 up to I would say between $15,000 and $20,000 and $100,000 are probably where you see most settlements. And again, there's a division between some of it goes to penalties, some of it goes to attorney's fees. Again, it is a lot of factual circumstances, and it also depends on the plaintiff firm you're dealing with, some of these folks are more difficult to deal with than others.
Great. Well, I just wanted to thank you, Lee, so much for sharing all this great information with us today. I'm sure everybody else is thankful as well. And I'd also like to thank each of you for attending today. I've had a couple questions about this, so I'll mention it. Shortly after the presentation, I will distribute a copy of Lee's presentation, a recording of the webinar, as well as his contact details. Please do not hesitate to reach out to him if you have any questions. And thank you again for the presentation, Lee.
Great, you're welcome. Thank you.
Have a great day.
Thank you. Please stand by.